Okay, can I address that?
Pardon?
Can I address that? I don't mean to interrupt you, but you and I have had this conversation. I'd like to inform the other people about this conversation that you and I have had. Because of Carol Dayton, you and I had this conversation back in 2003.
Right.
And I've recorded here, I don't have copies for everybody, but I can make copies available on the internet or Cellcan of the history of that conversation. Because you haven't answered a question. I don't mean to be point blank about it, but you know, I think this is an important point. A proposal was made because there's a loophole in that code. We're talking about code, Ohio Revised Code 2107.081 through 85. And in particular, the loophole is involving 2107.084 C and D, paragraph C and D. Basically, you go through the protection at the time that you're competent like you are right now. You go before the court. It's an adversary proceeding. Make sure everybody's rights are protected. You're trying to safeguard your heirs' interests. But what happens when subsequently you have Alzheimer's and you're supposing one of your children wants you to sign a different will, giving them more of your property than the other person? So they have you make a change to that will. Well, under paragraph D, there's no protection. And you have no ability to put a protection in place such as paragraph C would allow, which allows you to go through the same proceeding to make sure that the change is protected in the same way as the original document. So in that regard, I proposed and addressed this to Carol, and Carol kindly responded at that time. Now she might want to, and I'll state beforehand that she became confused, and I discussed this confusion here a little bit. And I believe Judge Swift contributed to that confusion a little bit. I gave Carol, right, but I'm just trying to make it clear because this point has been raised and I think we ought to address it thoroughly. But I would like to make it clear about one thing. I've asked certain questions for 6 years, and Judge Swift and others, not just Judge Swift, it's not just him, but others have refused to answer. So I'm going to ask you one question when we're done here. But first people have to understand the context of the question. I gave Carol a document called Self-Proof, Self-Propagating Advanced Declarations, in which I explained the proposal and gave her an example of how it would work. And so I have that here. We can enter that in the record if Ursula wants to. And I have a couple copies, but I don't have enough for everybody. Carol wrote on December 8th of 2003, I think this is a user-friendly presentation as well as persuasive. I have a couple of questions, and she goes on and asks the questions. Then on June 25th, 2004, approximately 6 months later, I got a message from Carol saying, Tom, I spoke with Judge Swift yesterday. He conveyed to me his opinion that your recommended revision of the ORC is flawed. Okay, well that's his right to say so, and I appreciate his input because we want to address flaws. I mean, just because I have a certain perspective or proposal doesn't mean it's completely right. And he had explained his concerns to you in your phone conversation. He has concluded that further conversations would not be productive. Now that's contrary to what Judge Swift said to me at the time of the conversation. He thought that we could have more conversations and it would be worthwhile. I hope that you can develop conversations with some of the elder law attorneys that you contacted to learn how to revise the recommendations. And I do have several attorneys, some of who are chairs of like the elder law section in Michigan, at least 2 of them former chairs of the elder law section, who believe that what I'm doing is pretty much on the mark. I have a email dated April 30th of that year, so a little bit before Carol wrote me, which I wrote to Judge Swift. And I indicated, the key here is, I remarked that Judge Swift indicated that the change I proposed would be struck down our courts as a restraint upon wills, even though it is the testator himself who imposed that restraint. And I asked, why shouldn't a person have the right to impose this particular restraint, especially when he invokes his right before court and notifies all persons expected to have an interest in his estate as required by other paragraphs of this code? And that's still going to be essentially underlying the question I'm going to be asking Judge Swift. Why shouldn't you have the right to impose upon yourself this kind of restraint to make sure that things are done the way you want them done, not just the way the court wants them done?